Good afternoon, everyone. We're going to call the Thursday meeting of the Judiciary Committee to order and begin the process. We have before us a number of bills. Let me get my sheet up here. We have 4 bills, and the order in which I want to take these. I know, Mr. Powell, are you in need to be to another committee, or are you time-wise? What's your situation? All right, does anybody have a driving need to be with another committee at this moment? I want to take up the first bill would be the one dealing with the magistrate courts, House Bill 705. And if you will bear with me, we'll pull that one up on top. While we're getting that up, let me also recognize, I believe, Judge Bert Guy from Brunswick is with us today, and Lawton Stevens is off somewhere else. Okay, we're glad to have you. Any other judges? Oh, excuse me, I forgot Judge Jim from Fulton. I'm sorry, I lost your last name, Jim. Altman, that's right, Jim Altman from Fulton Magistrate Court. So this will be of interest to you, right? The House Bill 705 we have had under consideration before. The bill is a change of the amount, the jurisdictional amount for the magistrate courts statewide. The desire is to change from $15,000 maximum dollar amount to $25,000, and I'll read the language in the current proposed bill, which is, if you will, look at with me House Bill 705 LC 29 7860S. If you would allow me to read to the audience, paragraph 5, the trial of civil claims alleging tort in which exclusive jurisdiction is not vested in the Superior Court and the amount of demanded or the value of the property claimed does not exceed $25,000, and the trial of all other civil claims including garnishment and attachment in which exclusive jurisdiction is not vested in the Superior Court and the amount demanded or the value of the property claimed does not exceed $15,000, provided that no prejudgment attachment may be granted. That is the proposed change of language to section 15-10-2, paragraph 5. In addition, the proposed change under this substitute is at 15-10-80 relating to the filing fees. It says, upon filing of any civil action, the plaintiff shall pay a filing deposit as established by local court rules not to exceed $40, which shall cover the cost of the action except service of process. That's not the same, though. I'm sorry, you didn't give me this one. Okay. My mistake, folks. Let me start over that last paragraph. That was not correct. I want to read, this is the language. Have you had this passed out to the committee members?
I'm doing it right now.
Oh, God.
I had it.
Okay. Section 2, which is under Code Section 15-10-80, relating to filing fees. Paragraph A, upon filing any civil action, the plaintiff shall pay a filing fee deposit as established by local court rule, which shall cover all costs of the action except service of process as follows. 1, where the amount of the claim does not exceed $15,000, the filing deposit shall not exceed $22. And where the amount of the claim is $15,000 or greater, the filing deposit shall not exceed $40. So we have recognized that with the increase in the jurisdictional amount from $15,000 to $25,000, there would be an additional cost involved for filing fees of another what amounts to $18. It goes from 22 to 40 only on those particular claims above the $15,000 threshold. Now, this is Mr. Kelly's bill. He is not here today. I think we do have some people who wish to speak to the bill. And I have the sheet. Sorry? Yes, ma'am.
Are we dealing now with 215941S?
You are. I apologize. I didn't have that in my hands when I was reading to you earlier. That's what I made a mistake on. So pull the other one aside. Ignore that. And also the original, which was 297652, that can be put aside. We're dealing with 215941S. Judge Altman, I missed your name up, sorry. Come forward. We'd like to hear from you. The Fulton Magistrate Court.
Thank you, sir. Good to see you.
Nice to see you.
Thank you, members of the committee. I am James Altman. I'm on the Fulton County Magistrate Court. I'm the Rules Chairman of the Council of Magistrate Court Judges and a member of the Executive Committee. The council supports the bill. We haven't had a chance to actually vote on the fee portion of that, but in discussions of it, I think we're quite accepting of the fee increase. The original fee of $20 was set in 1983 and was increased to $22 in 2010. So it's certainly been quite stagnant for quite a long time. I don't think there's been much discussion of exact amounts, but certainly the principle will be acceptable to the council. The council would also like to point out that the last time there was an increase in the jurisdictional amount was 1999. It went from $5,000 to $15,000 at that time. Inflation since 1999 would get it to about $22,500 today. So it's not far off of what inflation has already done to the $15,000. We, in paragraph 6 of that statute, already have unlimited jurisdiction over dispossessory actions. So the magistrates are already used to dealing with numbers far larger than $15,000 in that context. So I think that our membership, the education, the experience, the training that we've had is well suited to this. We do want to point out that this was not our proposal. We do support it. We think it makes sense. But we're not the ones originally creating it and setting it forth. Other than that, I think there's been some fair discussion of this already that a number of the members have already participated in. And if you have any questions, I'd be happy to answer them.
Thank you, Judge. Does anyone have a question of Judge Altman as a presenter? Yes, ma'am. Ms. Oliver.
In DeKalb County, the state court fee is $232, something like that. And the previous substitute we were looking at was kind of trying to address the loss of income to the county for this jurisdictional change. How is the extra $100 fee in Fulton County State Court apportioned? Does it go, is it decide, how does it go?
I really don't know.
Okay.
How state court allocates that.
But they collect it.
But they collect it.
We've got someone who probably does have information on that. I see her looking at me.
I sit as a state court judge more than I sit as a magistrate, but I don't deal with the money.
I'm just trying to figure out how much this is going to cost DeKalb County.
That's when we look raise the fees, recognizing there will be a shift, a nominal amount of cases shift from state or superior court to magistrate court dealing with these smaller sums, but still hopefully expediting these type claims for resolution quicker.
And I don't want to speak for the authors of the bill or the persons who came up with it, but I think what they were trying to do was match the minimum limits of liability in car accident cases to the jurisdictional amount, because
that's one thing.
That was one consideration that they had, because we try an awful lot of car accident cases as it is. So.
All right, thank you, Judge. Any other questions from the members of the committee and Judge Altman? Yes, sir.
Mr. Chairman, the effective date, if, whenever you bring the suit or when the accident occurred?
I think procedurally you're talking about
Whenever you
the
bring the
case,
suit.
the procedurally, what's the word we're looking for? Perspective.
Uh-huh.
I think that once you change the jurisdiction, it would allow a claim that has not been brought yet to be brought in that court.
That's what I thought too. Thank you. Does that sound right?
I would agree with that.
Yeah, okay.
Yeah.
All right. Thank you.
Thank you. We appreciate your support.
Thank you, sir. Ms. Nesbitt, would you like to come up and talk about the fee issue on behalf of the counties? Happy to see you.
Thank you, Mr. Chairman. Deborah Nesbitt here representing the Association of County Commissioners. Thank you for allowing me to talk today. So I'm assuming that this new sub does not have the Section 3. Okay, it's gone.
It's gone.
So
Except
to
for the,
answer Representative Aller's question, the split of the Judicial Operations Fund and State Court is $50 is retained by the county and $75 is sent to the state under that add-on that is not in magistrate court.
but all magistrate fees remain with the county.
Yes, sir, they do. All magistrate fees remain with the county, and we appreciate the consideration of the increase in the fee on these higher jurisdiction cases. But again, when we ran this against the CPI, since the fees were raised, the fee ought to be between $40 and $50, even on the lower end cases. So, I mean, I have to say that we would appreciate a small increase there as well.
Work on it next year.
Okay, would greatly help us.
Increments.
But it's
Increments.
Small bites. Is that the way you would
I think so.
characterize that?
I think
Yes.
you've got a question from Ms.
Okay.
Oliver.
But we don't have any data, obviously, I'd assume we don't, that would say how many cases between 15 and 25,000
May move. No,
that
ma'am.
would define the loss to the county or the state.
No, we do not have any kind of caseload data that would show us how many of those cases would shift or could potentially shift over to magistrate court.
Thank you. Any further questions for Ms. Nesbitt? If not, we
Thank
appreciate
you.
your input. Before we close off, does anyone else in the audience wish to address the committee on House Bill 705? If not, we will close off further public input. The bill is now in the breast of the committee. Do we have any discussion among committee members relative to House Bill 705? If not, the chair will entertain motions. We have a motion, do pass. And we have a second. Any further discussion on the motion? Any amendments? There being no amendments, the chair will call the main question, which is a do pass recommendation to House Bill 705, which is LC 215941S. It's do pass by substitute. Thank you. All in favor signify by saying aye. Opposed, like sign. One no, the motion carries. 3 to 1. Sorry? All right. That's number 2, yeah. Next, we'll call up Mr. Corbett's bill, abandoned mobile homes, House Bill 381, and I think we're working off the correct number here from LC 391819. Is that right?
1819 ERS, yes.
Yes, sir. Yeah. This is a bill with some substitutes to it, Mr. Corbett, which I'll get to. You might want to talk about, address your bill to the full committee, and then we'll have other comments from members of the public, and then discuss some changes that we're looking at.
Yes, thank you, Mr. Chairman. I want to first thank the committee. Thank you for working with us on this, and Chairman Fleming, thank you for his help. Thank Jordan, working with Ledge Council. I appreciate his help as well. Mr. Chairman, first, I bring before you today House Bill 381. The reason why we needed this bill, we went over the other day, but I had a probate judge or magistrate judge in the county that I live in came up to me and said we need to do something about the procedure of being able to deal with abandoned mobile homes. So as I started researching what the process was, other than the county having a tax sale on it, the landowner, his only other recourse was to hire a mover at an expense of $1,500 to $2,000 to move it to a secure lot and pay a storage fee on it, and $3 to $4 a day or whatever that storage fee was, and unlimited. It had to stay there from now on because nobody's going to come claim it. And a tax sale, getting back to that, this is some of what we're looking at. Something like that, nobody's going to buy it, so it's still, you hadn't solved the problem even if you go to a tax sale. So as I started digging into it, and I've worked with ACCG, GMA, the bankers, credit unions, realtors, as we worked through this process to try to come up with a procedure that would work for everybody, and that's why we need the bill. If you'll, we'll go through the bill and kind of explain it. That's how I understand it. And
Yes,
like I said the other day, I'm not a lawyer, but sir.
And what we'll do, Representative Corbett, as you go through the bill, there have been some things modified
Yes.
for this committee, and I will point those out as we talk about the sections.
All right. Thank you, sir. All right. Basically, lines 35 through 64 just deals with definitions. You know, defining what abandoned mobile home is, what derelict means, what intact means, dispose of, what that means, what a landowner means, local government agent, and also what a responsible party means. Just anyway, definitions 35 through 64. All right, on 56 and 57, before we leave there, I want to point this out to the committee, that nothing in this article shall be construed to require a local government authority to appoint a local government agent. This is a voluntary program. If a local government decides to do this, it's voluntary.
Yes.
For them to participate in this. All right, lines 66 through 70 deals with the process that starts with the request of the landowner. So if the landowner doesn't request this, even if the county's participating in it, they can't go out to his property and tell him, hey, you need to try to start this process to remove this mobile home. It's at the request of the landowner that this whole process is started.
Let me point out to the committee the change that we made on lines 73 and 74. You will see that we've added at the beginning end of line 73 the phrase "as of the date on which such lien is filed." So that will be explained a little later as we get into it.
Yes.
But this is recognizing if there's this lien being started, there will then be a potential rental amount that will be accruing.
Yes.
That the possible lien holder may have to pick up.
Yes.
Okay.
Thank you for pointing that out. And again, 71 through 75 just deems it an intact mobile home that the landowner has the right to file a lien.
Correct.
All right, then 76 through 127, the lines deem, if it's deemed derelict, it's the process of which the notification of responsible party takes place, certified mail. If they can't find them, you post it at the courthouse at the place they advertise at the courthouse, or in a newspaper. You run that article, and all that procedures in there to do that. You know, if nobody comes and contests the ruling, then the landowner can receive it, or if they contest it, then it goes to a hearing, and it's deemed derelict. After that process, the landowner receive a permission or permit to dispose of the derelict home, and he has to do that within 180 days.
And we added on lines 125 and 126 a notice also to go to the local tag agent, which would be the county,
Yes, yes.
usually tax commissioner's office.
Yep, that is correct. Okay, and that takes care of the derelict portion of the mobile homes if it's deemed derelict. The rest of the bill starting, I guess, lines 129 on deals with if the mobile home is deemed intact, which is livable condition.
Correct.
and then anyway, it goes through the process to foreclose that lien. 196.
Let me hold you up there because we also have a number of changes. I'm going to point out to the committee on lines 133, 134. We have recognized that the magistrate court of the county where the mobile home is located would have jurisdiction to consider these type of actions. And so that will help, I think, as opposed to going through the Superior Court on that lien perfection. Then also you have lines 137, 38, and 39. We say we added in the amount of the lien, and then we say for the payment of the accrued after the filing of the lien, as we recognized earlier, provided that the rent amount, daily amount of such rent shall not exceed $3. And we didn't just pull $3 out of the air. If you go back up the top of the page, you'll see the line starting at 129, notwithstanding any conflict provisions in Code Section 44-14-349. Within that section is also a similar language about a mobile home where the lien holder is having to acquire the home, that the owner of the property be entitled to a $3 per day rent for past due money. So we use the same amount in that instance as for this type of thing, this purpose. Further down on line 142, we changed that to 30 days where previously it was 10 days. If within 30 days deliver the appropriate address, to give sufficient time for the right people to get out and take care of it. Line 146, we recognize the magistrate court again. And then on line 152, read some writing down here that we struck out a provision regardless of which court the affidavit required by this paragraph is filed. Well, we've changed that because the magistrate court is where it will be filed. And so that was just removed as a language didn't have any other purpose. And then on line 158, we again changed that to the 30-day provision. So those are the changes on this page that we've taken care of. And then the next page, 160, you were down through page, bottom 19. Let me go through here. Change again, 166, 167 is magistrate court. 171 is magistrate court. 75 magistrate court. 78 magistrate court. 181 magistrate court. 185 magistrate court. And 193 magistrate court. So we just all the way through recognize the magistrate court as the court referenced in the bill. Thank you, Mr. Corbett.
Thank you, Mr. Chairman. And then starting in 196 through lines 215 deals with the process of having a public sale. Tells about where it's to be held, the advertisement that has to be done, the time and dates, and then what to do with the proceeds, if any, is exceeds the amount of the lien, what to do with the excess, the remaining.
Yes,
You give that to the clerk, turn it over to the clerk, and then 217 through 223.
Let me hold you right there. We're on line 206. We had the same times as we do for regular property foreclosures. Changed ahead 9 o'clock, 5 p.m. We changed it 10 to 4, which is the normal foreclosure hours in Georgia. Right? Okay. Then we added magistrate court on line 208. So now we're down. You're down to what? 230.
217.
217.
217 through 223 just states that the clerk is to retain any excess over what the lien was executed for 1 year, and then if nobody makes a claim against it, it's to put in the general fund. And then 225 through 230 just basically deals with giving the purchaser the authorization to receive a title. You apply to Department of Revenue to receive a title.
Right.
For that. And then 232 to 239 just deals with the foreclosure of abandoned mobile homes will be under the jurisdiction of the magistrate court.
And what we added here was on line 238, is just recognizing the foreclosure of the lien for an abandoned mobile home is as guided by Article 6, which is the first section 1 of the bill.
Yes, sir. And that's the bill. I will yield for questions if there are any.
Do we have any questions by members of the committee for the presenter? If not, we seem to cover it. I want to say it's been quite a process getting to this point, but it's a good thing to have happen. Surprised we haven't tried to address this sometime in the past as far as abandoned mobile homes.
And again, I want to thank you and the committee for working with us on this.
All right, good bill, I think. And see, we picked up some more members. We're on House Bill 381. Does anyone else in the audience wish to address the committee on House Bill 381? Yes, ma'am. All right. Got it covered. Thank you. And no further comments. We'll close off further public input. The bill is now in the breast of the committee. The chair will entertain, is there any discussion on the bill first? If not, we will entertain motion. Have a motion to pass. It's been seconded. In discussion on the motion. This is 381 as a committee substitute, by the way. LC 39-1819 ERS. No further discussion. Any other motions for amendments? If none, we'll call the main question, which is due pass. House Bill 381 is LC 39-1819 ERS as a committee substitute. All in favor signify by saying aye. Aye. Opposed, like sign. The motion carries. Recommendation. Thank you.
Thank you.
Mr. Caldwell, I'm going to pull yours up, then we'll, no, but stop, hold on. Hold on, go ahead and get Mr. Powell, you're next. Excuse me. I think a number of people here were ready to talk about condominium fees. Come on up, Mr. Powell, and we're going to be on House Bill 704, and we also again have I'm sorry, 410, my mistake. House Bill 410, excuse me.
Mr. Chair, if you don't mind, I'd like for Keith Hatcher to join me, and y'all have the latest substitutes.
Okay, let me get up here. Yeah, let me get the right LC number up here. Got the wrong bill here. Just a second. Chance to fumble through all the paperwork we got. We're dealing with 410 LC number 8715 ERS. Correct?
Correct.
All right. Proceed.
Well, I understand that
Get
the
where
chair.
both mics can get. You might want to put on the other side, Mr. We're going Keith at you.
Thank you, Mr. Chairman.
There you
I
go.
understand that y'all have a committee sub.
We have. This one I just read is the LC 288715 ERS.
Right.
And I can touch on the changes, amendments we're looking at here. Main thing we're talking about is the fees that we're looking to allow as a maximum amount for the purpose of obtaining the information and a listing of what is that information that has to be provided for a buyer or lender, as the case may be. If you look over on page, starting with at the bottom of page 2, you'll see beginning at paragraph line 42 is a statement of account, as we call it, may be completed by any officer, authorized agent, or authorized representative of the association, including any authorized agent, including representative or employee of a management company authorized to complete the statement of account on behalf of the board or association. The statement of account shall contain all the following information regarding the property for which the transaction is to occur and shall be in substantially the following form. A, date of issuance. B, name of the lot owner or owners as reflected in the books and records of the association. C, lot designation and address. D, parking garage space number as reflected in the books and records of the association as applicable. E, attorney's name and contact information if the account is delinquent and has been turned over to an attorney for collection. No fee may be charged for this information. F, the fee for preparation and delivery of the statement of account. G, name of the requester. H, assessment information and other information, which is as follows. 1, the amount of the regular periodic assessment levied against the lot and the frequency of payment. 2, the date through which the regular periodic assessment has been paid. 3, the due date of the next installment of the regular periodic assessment and the amount due. 4, an itemized list of all assessments, special assessments, and other monies owed on the date of issuance of the association by the lot owner for a specific lot. And 5, an itemized list of any additional assessments, special assessments, and other monies that are scheduled to become due for each day after the day of issuance for the effective period of the statement of account. In calculating the amounts that are scheduled to become due, the association may assume that any delinquent amounts will remain delinquent during the effective period of the statement of account. Then additional information under I is as follows. 1, any open violation of any rule or regulation notice to the lot owner in the association official records. 2, a list of any contact information for all other associations to which the lot owner is a member that comes by virtue of buying the property. 3, a copy of the current covenants and bylaws of the association and a statement of any encumbrances regarding the subject property. And 4, the signature of an officer or authorized agent of the association and any further pertinent information in the statement of account. Now, those are things which are to be furnished as necessary for a transaction of sale to occur between a seller and a buyer, to know that the buyer is receiving full information about what is expected of them and how much is the cost, etc., to be incurred. Section 3 is as follows. A statement of account that is hand-delivered or sent by electronic means shall have a 30-day effective period. A statement of account that is sent by regular mail or statutory overnight delivery shall have 35-day effective period. If additional information is needed or a mistake related to the statement of account becomes known to the association or its agent within the effective period, an amended statement of the account may be delivered and become effective if the sale or refinancing of the lot has not been completed during the effective period. A fee of not more than $50 may be charged for an amended statement of account. An amended statement of account shall be delivered on the date of issuance, and a new 35-day effective period shall begin on such date. An association waives the right to collect any monies owed in excess of the amounts specified in the statement of account from the person who in good faith relies upon such statement of account and from the person's successors and assigns. Any person other than a lot owner who relies on a statement of accounts receives the benefits and protection thereof. We then have the amounts that to be allowed as charges for preparation of the statement of account under paragraph 6. An association or its authorized agent may charge a reasonable fee for the preparation and delivery of a statement of account which shall not exceed $200 if a statement of account is requested or an expedited basis and delivered within 3 business days after the request. The association or its agents may charge an additional fee of $50. So those are what is proposed as amounts of fees, Mr. Powell, for your bill, and I would ask you to comment from there.
I will comment. I think the chairman has done an excellent job on this substitute.
End of story. Okay.
Mr. Chairman, I've been very pointed with no disrespect to the committee, but in my terms of coming down here, there's a lot of other committees that I prefer to go to, but I do know that this committee has some of the some of the most intelligent members of the legislature, and anything that I bring to it, I'm sure that y'all
Put that to a
will work it
motion,
out.
want to? Thank you, sir. Thank you very much.
Thank you, sir.
Mr. Hatcher?
Mr. Chairman, I concur completely with the sponsor of the bill. I know there are several members of the full committee that were not on the subcommittee, so to maybe help you with a little background, if you will indulge me just very quickly, the reason this legislation was brought forward is we found there's a problem at real estate closings. What happens is for the closing attorney to do their due diligence, they ask for this letter, this statement of account, ordinarily very close to the time of the closing because they want it to be an accurate letter. If you notice in the first part of the bill, striking existing law, on line 40, you will see what the existing law places a $10 cap on the fee for the statement of account. What we've learned is happening is we're getting I can demonstrate lots and lots of bills I can bring to you where they send the information and they say, here is your statement of account for $10, but we're going to need a $195 processing fee, $75 for a rush fee. They've made up a litany of fees that are not anywhere provided for under the code, so that letter ultimately costs $300, $400, or $500. The consumer is not aware of that until they're at the closing. At that point, they have thousands of dollars at escrow at stake whether they're going to close this loan or not. And so we feel like what's happening is they're being taken advantage of. The reason the law is on the books today, we think when they wrote this law, they were concerned about people being taken advantage of, so they put a cap. And so what we're trying to do is say today there's maybe more information requested than was requested under the old cap. So we approached the various parties and said, let's talk about what you really need today to close a loan and what will be a reasonable fee for that information. We started this last year. Chairman Willard, as he often does, in being very fair-minded, asked me, well, Keith, has anyone else dealt with this? Florida passed, basically, this is a version of the Florida law, very similar in terms of what they need in their price. We had hoped $100 we thought was a fair fee because, again, from our perspective, we're not asking for you to create some complicated algorithm. We're asking someone who is a community association manager to tell us, does this person owe you money? We think that's part and parcel of what they're supposed to be doing. If you're a community association manager, this information should be readily available. If you look at the list, it's not super complicated. So to say, tell me I owe you money, I've got to pay you to tell me I owe you money, okay, what's a reasonable fee that we know up front so the consumer is not surprised at the closing? What happens today, unfortunately, no consumer walks away from that transaction and files a lawsuit. All of their furniture's in a moving van, they've picked out the colors for the room, they basically are being extorted, in our opinion. How much can I force you to pay before you'll walk away from this transaction? And we think that's unfair, and we very much appreciate the chairman spending a lot of time and energy coming up with what we think is a reasonable approach, and I'm happy to answer any questions.
Any questions by members of the committee of Mr. Powell or Mr. Hatch? Yes, sir. Mr.
Are these fees, I would assume the major problem is the associations that hire an outside firm to handle, is that the main?
As a matter of fact, the fees, it's an interesting note, the fees that have been created that are charged, what we've discovered in our research is those fees don't go back to the solvency of the HOA, they go to the community association management company. So what we find happening is that management companies are using this as a tool to subsidize their income. I've got realtors who offer these services to communities and tell me they're having a hard time competing because their baseline price doesn't include charging these fees. They think these fees are unfair. So those fees are not part of they don't go back to the community, don't go back to the neighborhood, they go back to the community association management company.
Right, are these fees advertised on a website? Do the homeowners know?
No, sir. They're not. In fact, since you mentioned website, another problem we're having is that in some cases they send you to a third-party website, and the website says, I can give you the statement of account, but you have to purchase our package, which includes covenants and so forth, and that's $350. So I can give you your $10 statement of account, but you have to pay me $350 to get the statement.
So, I mean, if management companies were just charging 10, obviously they're gonna charge 200 now, which I would.
Yes.
So, I mean,
We're not excited about that. but again, we felt like trying to strike a compromise, what information's required and what's a fair price, that's the number that you're looking at. Again, I think Mr. Bruce raised the question in subcommittee. It seems odd that I've got to pay you to tell me that I owe you money. But that is, in fact, the situation we're in.
All right, thank you. Ms. Oliver, I think you were next.
I can't find it. It may be here, where if they're required to tell you what their reserves are.
That's an excellent question. I know I have the chairman's sub I just got yesterday. They made a few modifications. I'm not sure if that was in the Florida model or not. I've circulated I've tried to circulate every sub to the various lending communities, because what I've constantly told them is I don't want to craft a solution with a reasonable number that really doesn't provide you what you need. So I'm going to have to defer to them to say if that's something they need in the legislation to make it work for them.
One more question, if I
Yes,
may,
ma'am.
Mr. Chair. Lines 59 to 63 talk about periodic assessments, and I've been negotiating an assessment dispute on a anticipated closing in the last month,
Yes,
and
ma'am.
I don't really know what a periodic assessment levied is in terms of the HOA having said we're going to levy an assessment. We haven't sent you a bill, but this is what we're going to do, and the work's going to begin in March. I can't
Yes,
figure.
ma'am. I think what we were trying to get to here is not that situation, but on a month-to-month basis, if you said, what dues do you owe, we're also talking about on a monthly basis, what do you normally charge is I think what we're trying to get at here. But you are absolutely correct. You are still vulnerable to some pending situation, and I'm not sure how to address that.
Yeah, it's not covered.
No, ma'am. And I'm not. I wish I knew that. I know you've been practicing law quite a while. If you got an answer, we'd love to have it. But this language is not intended to address that problem, which still remains, but to say, we know on a month-to-month basis you're going to owe X amount of dollars.
To me, this looks like the purpose of you have a right to have this information, and if you ask for it for 10 days and you pay them either $50 or $200, they have to give it to you. This is what they have to give you.
Yes, ma'am.
And if you ask about reserves, which I did, or you ask about, they may or may not have to do it.
Yes, ma'am. Or they may charge some fee that's market-driven for that information because it's outside what's necessary for closing.
That's what we looked at. What would be required essential information to get a change of ownership, knowing what you're getting into. Okay. Anything further, Ms. Oliver? Yes, sir.
Thank you, Mr. Chairman. Mr. Hatcher, you did a good job of explaining
Thanks,
the situation. I've heard this bill for years, it seems like. I've been trying to get my mind around it because I'm not a real estate lawyer, so you did a good job. The realtor has a customer that wants to buy a condo. He takes them and shows them 2 condos. Make this simple. Condo A he likes, condo B he likes, so which one does he buy? And the realtor says, these condo A folks, they are hard to deal with. And let me tell you what's going to happen at the closing. They're going to pop a $500 fee on you for all this information. I just want to tell you that before you decide if you like A or B better.
Sure.
Why didn't the consumer just say, I like B?
Well,
And the condos that treat people this way don't end up being able to have a good job of selling their homes.
well, in a perfect world, that may happen. The
Right.
truth is, in a real estate transaction, I'm not sure the last time you purchased a home, but there's tons and tons of information being exchanged.
Lots of paperwork.
And so I'm not sure, if the agent is doing that. I'm not sure the agent should have to do that. The General Assembly saw fit to put a cap into the law years ago to prevent this kind of abuse outside of any sort of education. They said there should be $10 fee for this information at closing because the consumer is vulnerable to being gouged because they don't have another option. I cannot go to another HOA and get this information. I have to have it from this particular entity. And so they do not take advantage of me at the closing. The General Assembly said, you're allowed to charge $10. Today they're charging $300, $400, $500 with these fake fees they've created that are not provided for under the code. Nobody sues them because at that point I've closed the deal or not, and I'm moved on. So we're having a hard time getting our day in court because nobody wants to be a plaintiff. They want to move into their house.
Thank you.
Any other questions of Mr. Hatcher or President Allen? If not, we have several people who signed up to speak to the committee, and the first is a gentleman I've known for many years, George Nowak. Mr. Nowak.
Good afternoon. I'm going to defer to Dennis Hoffman. Dennis is principal in a management company.
All right.
Seems the best person to start out with is the person directly that
You want to come with him, or you want to just let him alone, or
George, only if you want.
the only?
Good afternoon.
Good
Mr.
afternoon,
Chairman,
Mr.
members of
Hoffman.
the committee. Thank you for this opportunity.
Yes, sir.
My name is Dennis Hoffman, and I'm the president and the qualifying broker for the largest property management company in the Southeast. We've been in business since 1989, and this is a primary part of what services we provide, which, by the way, are outside of our general contract with our management, with our clients, in providing the services for the management of their community. During the vetting process, hiring process, these questions are asked by the boards of directors, and we clearly identify what our fees are to them. The listing agreements, particularly the 2018, that realtors and homeowner disclosures have to provide, clearly point out in them what are the closing cost fees, who's going to pay them. The latest one says the seller will pay for the closing letters. Our fees are market-based, have been market-based. We believe that if it's a necessity that a fee be set, the tested model in Florida seems to have worked, and by the way, that is the average fee, which is $250 for the letter around the nation. There are 10 states that have caps on theirs. Their average is $250. We've heard various people state that there have been exorbitant fees provided for a statement of account. If you look at a statement of account, it is purely and simply a number that reflects what is owed, if anything, on a particular person. You cannot close, realtors, closing attorneys will not accept a letter that says Unit 468 has a balance of 0, period. Thank you for your time. They want to know what are this additional information. So we believe that a disclosure package providing all these issues that Chairman Willard has included in his bill is appropriate. We want to be transparent. We want to have knowledgeable buyers in our communities, and we want to assist the realtors who constantly request additional information from us to assist them in making these sales occur. Setting the statutory requirement, I believe, is valid, but setting the fee that you want to set just because that seems to be a reasonable fee does not consider, I think, the amount of work and time that we put into providing these letters and the additional information that is constantly being requested from realtors, homeowners, buyers, sellers during the process. Thank you for the opportunity, and happy to address any questions.
How much per hour do you pay your personnel as far as the office people who are doing this, I call the work of pulling together this 40s
A year,
per hour, 40,000?
40,000?
Break it down to an hourly amount.
I don't have my calculator in front of me, but
Well, let me say what we looked at
20,
doing.
40.
What we tried to do here is look at what would be required in my talking with the other people who do this type of work. And you say usually about 4 hours time is what you're looking at as a time to compile all this data. It may go a little less, it may go a little more, about 4 hours at the most. So we said, okay, $40 to $50 an hour would work out to the range of $200. Now, they say, well, we got to have it tomorrow. So you're expediting it. More time may be necessary. So we agreed that another hour should be added to that. That's why we put that extra amount for expediting the time frame.
Jim
Mr.
Willard,
Hoffman, that's what we're doing.
I understand, but, you know, in addition to that $40 that we pay the individual, we have overhead, we
Well,
have profit, we
I'm
have
including,
insurance.
I'm including what would be, what you call the social security cost, everything goes with it from, I mean, if I don't want to calculate it out, but what is $40 an hour?
10 is 20,
$20 an hour.
$40,
40 times 20,
yeah.
2080?
40,000 is $20 an hour.
Yeah.
So double that, 80,000. I don't know if these people are making 80,000, but that would be a nice job for them.
Well, with benefits, we provide,
Yeah, yeah.
you know, certain
Yeah.
benefits, health insurance, et cetera, to all of our employees as a part of our business
Yes, sir.
model.
You have a question?
Yes, sir. Mr. Hoffman, thanks for coming today. So I want to be clear that I understand. Are you for or against the proposal that's in front of us?
I'm for having a disclosure package.
Yeah.
I'm not necessarily for setting a fee that doesn't have an opportunity to be raised or increased. And I do believe that the rush requirements, the instantaneous I need right now, I'm sitting at a closing table, that dollar amount of an additional $50 does not seem to be adequate in my mind.
Go ahead, Mr.
I was if
Chairman.
Lori calls you up saying, I have it right now, you say, I'm sorry, sir. We'll do it on the basis that we're able to get it to you. That's his fault, not yours.
And I understand that, Chairman Lord, but unfortunately, the closing attorneys, the realtors, are not willing to accept that kind of an answer.
Well,
So that starts at the lower level in my firm, and
Okay.
before long, it ends up at my desk
Yes, sir.
with, what are you gonna do about making this happen? You're such a horrible human being because I can't get my commission check, or I can't close this thing.
Understand.
But I understand that.
Let me interrupt you.
No.
Excuse me.
Good question, Mr. Chairman. But, Mr. Hoffman, so if you, and here's what I think I hear you saying. I don't want to put words in your mouth. You're saying we're going to lose a little money if you do this to us, is what you're saying, right?
We're gonna lose a little money in that facet of our business.
Right.
We'll be forced to find other facets in our business, perhaps increasing the amount of management fees that are charged to the entire community. As a result, impacting everyone, even those who aren't planning on selling their units at any time.
So basically, the cost of condo living, selling, and management is going to go up a tad if we miss the number here. Is that what it amounts to?
Potentially, yes, sir.
Okay, all right. So the same people involved in the transaction are going to end up paying this anyway.
Yeah, the answer is yes, other than the fact that there are gonna be some people who are not involved in the transaction that are gonna have to be forced to pay a little bit more.
Thank you.
Yes, sir, Mr. Roger Bruce.
I don't know. I thought I heard you say that you're going to look at potential cost of this money. Right now, you get by law $10 to do the work you're talking about.
No, sir. We get by law $10 for providing a balance, a statement of the account, period.
All right, but you get, right now, the only thing that's in the law is that you get $10 for doing what you just said. This bill, you're about to get a hell of an increase from $10 to $200. So I'm confused as to how you losing money when you're getting ready to get way more than you were getting before.
Because we are not getting just the $10, because they're asking for additional information above and beyond to which we charge a fee for.
Okay, and you're now getting additional money with a list of things to show what that additional money is covering. So I'm at a loss for understanding how you're losing money when you are in fact getting $190 more than you were getting before. And yeah, there's a list of things that you have to do, but you were doing those things anyway and charging a different fee. But that wasn't legal to do, is my understanding.
Well, I don't believe it was illegal to do that. We were providing them in the Condo Act and the POA, Property Owners Act.
Pull your mic around, Mr. Hoffman, mic, so we have.
POA with the $10 statement of the account and then additional information required at additional fees that exceeded or are about at the 250 fee for the closing letters.
Okay.
Got it?
Thank you.
Anything further for Mr. Hoffman by members of the committee? If not, we appreciate your
Thank
comments
you.
and coming
Thank
today,
you.
too. I think next we have Randy Lipschutz. If you want to come up, Mr. Lipschutz. Like I say, I knew Mr. Nowak when he had dark hair. I knew Lipschutz when he had hair. So, go.
I knew you, and neither of our hair was quite so great. Mr. Chairman,
Happy to have you with us.
thank you, Mr. Chairman. I'm Randy Lipschutz. I'm here on behalf of Community Association Institute. And my purpose today is really just to address the bill and the way it's drafted. Over the last couple of years, I've had any number of conversations with the chairman, with Mr. Hatcher, with any number of people, as have others, to try to come up with a solution to what has become a problem. And Chairman Willard's come up with a bill as a substitute that seems to address most of that. My concern today is not to address dollars. I'm not affected by the dollars. I'm not a management company. I don't get the fees. I don't know whether 200 is right, 250 is right. Average is 250, but that's not what I'm here to address. The things that I wanted to address to the committee were just some of the drafting issues in the bill to see if we can make a better bill. If I start, I'm going to start with line 23 of the committee substitute. And that's an area where you provide for how a statement of account is to be issued. One of the ways that many of the companies and many of the associations provide the information now is by electronic download from a website. That's not really provided for in here, and I think it might be appropriate to add that as an alternate means of delivery. Representative Oliver, you had a question? Okay.
Email doesn't cover that. So.
Email doesn't cover that because they download it directly from the website, so it's not really coming by email. I think that would be a help to the statute. On line 51 of the bill, where it says lot or address, or it says lot and address, that probably should be or address. We're trying to designate what the property is. The property management company may not have the lot number off of the plat down at the courthouse. They may, but they may not. So lot or address probably would be a better way to word that. Line 52, where you're talking about parking spaces, although it doesn't really apply in most homeowner associations, it would certainly apply in many condo associations, but perhaps preface that as assigned parking or garage space numbers. Many associations don't have assigned either one. They don't have assigned parking, they don't have assigned garage spaces. And to limit it to assigned might make it a clearer provision. Line 76, I'm trying to go in order. Line 74 and 75, where we talk about other associations. Chairman Willard, I think, indicated when he was talking a little while ago appropriate language, but it's not really in the bill, and that's probably needs to be added, and that's to add other associations that the person is a member of by virtue of ownership of the lot. That's not in this. If you have a master association, I'm sorry.
I think it's in here, but not that location. Let's see. Where was that? I read from it, I thought.
If it's there, I may have missed it. I got the bill yesterday, so
Yes, sir. It's on 74, a list of and contact information of all other associations of which the lot owner is a member.
Right, and my suggestion was add after that by virtue of ownership of the lot.
Okay.
Okay, line 76 and 77, I need to ask the chair what we're trying to get at that point. I don't think the association is supposed to be providing a title report on the lot, but it reads that way, the way that it's written right now. I mean, if we're dealing with encumbrances that affect the property as a whole, then we can probably address that in case you have a building that has a lease on it or a
What we're
land lease or
looking at is
something.
you have recorded covenants that apply to a, say, condominium or even a homeowners group association. And that will not always be a part of the public record, perhaps,
No, it would be.
or should be.
It should be.
Should be.
And I'm not worried about giving people copies of what's
But
on the
that's
public
something,
record.
I think the association management company for their client will have that information because it's something they have to refer to, I'm sure quite often.
Well, but they
Great
may not have a copy of a Georgia Power easement, which is an encumbrance
Well-
across part of the I'm just trying to clarify what it is that we're trying to provide. Certainly want to provide anything that's going to affect
I
the
think
homeowner.
covenants and bylaws.
Covenants and bylaws, certainly.
And I guess I was looking at encumbrances where you may have restrictions on how the property can be used, which may or may not be within the covenants.
Well, if you're going to rules and regulations, that's really not going to be recorded. You may refer to that, but that's not an encumbrance on the property. If
So-
you want to add rules and regulations, that's perfectly appropriate.
So you have things like you can't paint your house with this particular colors and.
That
you
would be a
gotta-
rule and
anytime-
regulation.
Anytime you come back, you wanna change the door, you gotta get our approval.
You could have architectural standards, you could have rules and regulations, and if we want to add that, that may be appropriate. But encumbrance will
Okay,
also
I
include
understand.
easements that just may affect the corner of the property where the power line goes across. I'm just trying to get
Yeah.
clarification.
The encumbrance may not be the term that you wanna use it, what you're saying.
Yes, sir.
And I'm trying to find out what is the appropriate term. I'm talking about things like statement of architectural requirements, what do we want to say there?
You could put in rules and regulations adopted by
Okay,
the association or by a committee of the
let's say
association.
rules and regulations regarding the subject property. How's that?
That would work, and certainly the management companies have those available.
Yeah,
Can do those.
okay.
Okay.
What kind of variance? Ask him.
What about for when the HOA allows a variance? For instance, they'll take care of your retaining wall, but not your neighbors, which is outside the scope of the rules and regulations. So it's not going to be necessarily filed with anything in the county or the state, but it would be something that the HOA would know, and they would let their management company know.
I'm not sure that I follow. I mean, normally if I'm representing an association and there's something that we're doing for a particular lot or that's different for a particular lot, we would record something on the court records to show that so the lot owner would know.
I mean, anecdotally, so for instance, if the HOA itself, they don't want to pay for that, so they just let it be known within their management company. They don't file it with the, I know a lot of HOAs, because they don't want to deal with the filing fees, they just keep it recorded in their own logs, and they keep it with their management company.
Well, then you get to my role as a professional, as an attorney that goes after associations that don't follow their own rules. Sometimes that happens. And as Chairman Willard knows, I think, and my colleagues know, I'm one of the attorneys out there that will take an association to task for that. But I don't know that that's appropriate to put in the statute as part of what's being given as a disclosure package.
All right.
The legitimate concern, but I don't know that it goes in the statute.
What's your next one, Randy?
On line 79, again, I'm not certain what we're trying to get to and what pertinent information might be. If we're trying to go after a particular issue, I would think
Well,
we'd write it in.
It was sort of an all umbrella thing. If there's something we haven't talked about in the requirements here that may apply, like, say, a fee that's paid to this other association, umbrella association, other pertinent information. I guess we're trying to be sure to tell the management company, give them what they need to know as far as what their obligations are going to be as to the financing needs from their property.
Well, I think that we certainly need to cover the master associations, and
If there's nothing else, they don't have to worry about it.
yeah, I think we certainly need to cover master associations. Where did I get my page numbers?
78 and 79?
Yeah, 78, 79 is where I was talking about other pertinent information.
Yeah.
You know, you provide the information like we talked about a minute ago by adding information about other associations that you're a member of by virtue of also owning the lot. That would cover your master association.
Okay.
We're adding that back at 75. I'm not clear on what pertinent information is.
I like it. Only for a reason to say, if there's something else there, go ahead and disclose it. We haven't touched on it. That may be a part of the financial needs.
I like to avoid fights over what the language means if we can, but, you know, certainly the intent
Keep that in mind.
Certainly the intent is appropriate.
All right.
In the short time that I've had to look at the bill, those are the specifics that I saw that were specific changes. There are a couple of things that I would suggest might be considered by the committee, some of which have been looked at and some of which may not have been. One is if an owner is delinquent in collections, the Florida bill has an extra fee that can be added to provide all the additional information that's required when you have a delinquent owner. Whether or not you want to adopt I think Florida has a $150 additional fee for somebody who's delinquent, whether you want to limit that to somebody who's delinquent more than 30 days so you don't have someone that's got a $10 charge getting charged an extra fee. But it's something I think may want to be looked at along the line of the Florida bill. The second thing, and Chairman Willard and I have discussed this, I think, in the past, is that $10 figure that was in the statute from back in the 1970s was difficult to deal with because it was static. The Florida bill has a CPI index on their fees every 5 years, and that's just something to consider.
We did.
Okay. That's fine.
We just think it's something to be reviewed
Okay.
periodically with the associations coming back and saying, hey, costs has gone up, something more is asked of us, what it may be, then we can consider that being a change to make.
It's the preference of the committee.
Thank you.
The other thing that I would suggest, having done closings in the past, although I don't do them now, but having done closings in the past, one of the things that has been taken out of the bill that was in the Florida statute as a required document that's covered by the fee is a certificate or information about any insurance provided by the association. That's something that no closing attorney is going to close without. You've left it out of the list of things to provide, which leaves it open for an additional fee, which I'm sure people will be happy to charge, but I don't know if that's the intent of the committee. That is something that you almost always have to provide to a closing attorney. But if it's not in the list covered by the cap, maybe there's an extra fee.
What is the need that the closing attorney has on having that insurance? This is the insurance the association, the condominium association, is providing for the buildings, the liability use of the property, whatever it may be, as opposed to the insurance that the owner has to acquire for his own property, which is be his contents, maybe the inside walls, whatever.
The need for it is that if somebody's borrowing money, the lender won't close without that insurance certificate. The lender wants to be sure that they are covered on their mortgage, and the association policy covers that. And so if you don't provide the insurance certificate, you're not going to close the loan.
Okay, got you. Good point.
So those are the things that I had come up with quickly going through the bill. I'm happy to answer any questions.
You do have questions, Ms. Oliver.
When this statute was originally passed, I think you said the 70s, I bet a lot of people who voted for it, and I wasn't here, thought that $10 was a cap for all and any and all services provided by the association. Do you think the $50 and the $200 set forth in this new version is a cap on any and all services that the HOA or the association could pay?
Well, the way that
could bill?
Yeah, I mean, the way that the bill is drafted, it is a cap on providing the things that are itemized in the bill.
So
just like
you
the
could s-
original bill.
You could continue to send additional money bills for additional services, like if I ask for reserves, or I ask for,
Right.
what does it mean about the association that,
Yeah. CAI drafted did some
CIA.
drafting on a proposal, and I think in our proposal, we would have provided that as part of the package. I think it's appropriate for the purchaser to get information on the reserves and not just the current operating budget. It's not in the bill as it's drafted.
maybe my question really Mr. Chairman, is can you assure me that we're not gonna be back here in another year that they figured out another way to charge additional fees?
Oh, I
over and ab-
assure you, nothing. I assure you, nothing. That's right. Next year, I assure you.
What-
But, you know, what we're trying to do, and one of the things Ms. Lipscomb points out, we probably should have the insurance there. I was trying to cover what I see to be the things needed for a transfer of ownership. If you want something beyond that, if you want to know, you know, what have you spent in the reserves the last 3 years? I don't know if that's a proper thing, but, or how much do you really have in reserves? Is it earmarked for something? If you get that information, you know, maybe there could be another charge for it. But what you're doing is trying to say what is needed to have a transfer of ownership between two parties. And that's what I want to cover here.
I mean, I think a balance sheet from the association, which they can print off in 2 seconds off the computer, if you want to add that to the package so that the purchaser has that information, I don't think we wouldn't have any objection to that. It's certainly available. The problem we come up with is that when you're closing with ABC lender, they have a form that's different from everybody else's form. And XYZ lender has a form that's different from everybody else's form. And those really can't effectively be included in a cap because we don't know what those forms are going to be, and they change from day to day and month to month. And they're different for every association. So those ought to be able to be charged for at market rate. So there probably will be fees depending upon what lender the purchaser selects. But the basic information that you need as a purchaser, as Chairman Willard has drafted, you know, I think if we need to live with a fee cap, we live with a fee cap, but it's disclosure information that ought to be out there. I think CAI is certainly in favor of making sure that the people that are buying into the communities have that appropriate information.
Further questions, Ms. Oliver? Mr. Bruce?
Mr. Chairman, this question is actually for you, if I could. The intent in your substitute, is it to create a cap?
Is to create a cap that they cannot exceed a charge of this amount. It could be under that amount, but it cannot be over that amount as to those items which are essential for a transfer of ownership.
Okay, so given what we already know that they just make up stuff, or have been making up stuff, what is in here to protect, I guess? I think you were asking a similar question, but I know we can't predict what they're going to do, but what is the consequence for them doing it? Is there
If
something?
they try to charge more,
yeah.
I think the answer to that would be that it's closing her says you're by law restricted what you can charge as a cost for giving me this information.
And based on this legislation, if we pass this legislation, is there something in here?
But there's no criminal sanctions about it, no.
Yeah.
But usually,
Is it a civil suit?
You could have a civil suit that you damaged them as a result, loss of sale. Yeah, and those are things that could happen, but I think most of the associations say, okay, that's what the law says, that's what we'll do.
Well, and in the real world, I would like to believe that, but what it feels like, and I may be wrong, but what it feels like is that we're taking the same situation that we have right now with them exceeding the $10 limit and creating a cushion for them to go to $200 or $250 but still be able to do the same thing they've been doing.
Speaking to your $10, that was unfortunately very poorly worded, I guess you might say. Back then. It just said about that, how much do you have as amount owed?
Right.
And, you know, give you zero owed, it doesn't tell you anything. It
Yeah.
doesn't tell you how much a month you got to pay. It doesn't tell you what are special outstanding assessments that may be coming.
Right.
To be paid. It doesn't really give you the information about what your obligations may be and the ownership of it.
Right.
That's why we wanted to, okay, let's list these things out. What is an owner in need of knowing when he buys that property?
Right,
Sure.
and I agree with you that the $10 may not have explained everything, but the point I was making is that
Yes.
there was a $10 fee.
Yes,
It didn't cover everything that needed to be covered. Now you're trying to cover it, but it still will allow them to exceed it with other stuff. And I
Potentially.
guess I was trying to figure out if
Yeah.
there was some consequence, and
Well-
what I'm hearing is the consequence is a civil lawsuit.
That's why we're listing out what they're
Okay.
needing to supply with that $200.
Yeah.
Yes, sir.
Representative Bruce, if I may, I would disagree that that the $10 was supposed to cover everything that gets asked for. I've looked at the requests from the lenders that come in, and they are far more than a statement of account. The management companies have come up with fees they are charging to fulfill those requests so the transfers can close. I can't sit here and tell you with a straight face that there haven't been some abuses. I don't think they've been as bad as Mr. Hatcher suggested they were, but I'm not going to say there haven't been some abuses. Chairman Willard is trying to come up with a bill that will curb a lot of those abuses, make sure that everybody knows what the rules are, and then if somebody wants extra services, management companies will be happy to provide it as long as they're compensated for the extra time.
Thank you. Any further questions of Mr. Lipschutz? We're grateful for you being with us today, sir. Thank you.
Thank you, Chairman Willard.
We have anyone else? Did I miss any names of? I see other people who had interest in this in the audience. Anybody want to speak further?
Can I mention one thing, Mr. Chairman?
Come up, Mr. Hatcher.
There've been a number of substitutes.
Just come up first of all.
There've been a number of substitutes floated around trying to suggest to solve this problem. Again, I appreciate all the time and energy. I'm not sure this substitute covers both the condominiums and the POAs. The way and just looking at it, it may just be the POA situation. So we're hopeful that the committee would cover both the Condominium Act and the POA because the situation is the same in both cases. Our sub was thicker than this because it did cover both POAs, condominiums, and actually we also covered.
What's 44.3? Hit that 232.
And so I think the Condominium Act may be in another co-session because our bill was a little confusing. It looked like it repeated itself because it's all the same language, but we were placing it in both
This
of those
is just
sections.
POAs,
Yes,
not everything. Oh,
So we'd like to ask the committee to please also have it apply to the Condominium Act. And if possible, our language
Okay.
also covered covenants running with the land because every HOA may not be taking advantage of the POA code section. Your HOA has to elect
I
to do
understand.
that. So
I understand.
we're hoping it would apply across the board.
Chair is going to move the table, the Bill 410
Thank you, Chairman.
for this meeting. Any discussion on the motion to table? It will be tabled and we will bring it up at a subsequent date resolving that issue. And I apologize, I thought it was covered. Okay. Next we have would be Mr. Caldwell's bill, I believe. You're coming up, Mr. Caldwell?
Thank you, Mr. Chairman.
Yes, sir. We're on 704, House Bill 704.
Ladies and gentlemen of the committee, as we watch our mass exodus, I'm shocked no one else wants to talk about garbage burial. So, I want to thank y'all for your time. This is actually my first time presenting a bill before the full Judiciary Committee, so thank you guys. I appreciate y'all giving me the opportunity. As it seems like I'm stumbling over myself, don't be fooled. It's because I am. But I will try as a non-attorney with Judiciary to present this to the best of my ability. With the help of Subcommittee Chairman Fleming and his subcommittee, we pulled a substitute out yesterday, and I want to thank the members of that committee.
Let's
for their
talk about
time.
what we're working on. That's a good
Yes,
point.
sir.
We're on House Bill 704, but it's LC 363548S.
Yes, sir.
Correct?
Yes, sir. I believe so. Okay. So the version that we brought out of Chairman Fleming's committee yesterday, I want to make sure that as I read this, that matches what I think I'm looking at as well. Yes, sir. All right. Here's the purpose of the bill that we're looking at today. Since 1997, it has been illegal for a contractor to bury garbage on a lot after building your home for you. But we have a statute of repose that applies to all contractor deficiencies that lasts for 8 years. That then catches that garbage as well. What the effect that has is that it takes an average of 20 plus years for that garbage to decompose enough to actually find it. There's no plausible way for a homeowner to show up on their lot and do due diligence and find garbage that was illegally buried. So what you found is over the years, you have a handful of bad actors who will bury garbage anyway, knowing that after 8 years, they're off the hook. And that if a homeowner finds it 20 years in with a sinkhole or 10 years in because they're building a pool, there's no ability to hold them accountable. So that was what we were after in the bill, was to try to come and set up a structure under which that 8-year statute of repose would not apply to this deficiency specifically. We tried to mimic the only other carve-out in the code section that we found, which was a carve-out for stucco and exterior siding. The way they described that was as early as is discovered or should have been discoverable would be when the action could then begin. You'd have 2 years after that point. So after you actually found the stucco deficiency, or in this case, after you found the garbage buried, you'd have up to 2 years to then go hold that contractor accountable. We had a couple of provisions in this bill that we added in through the committee process that I was agreeable to, I think made sense. One of which was discussing evidentiary standard. Because we are opening this up in perpetuity, we set up an evidentiary standard that would require preponderance of the evidence prior to the 8 years and then shift into a clear and convincing evidence afterward. That way, in perpetuity, if someone found the garbage 180 years later and you had the most successful contractor of all time who was still in business, you wanted to hold him accountable. But it turns out it wasn't actually them. It was the guy who cleared the trees on the lot had buried all of his garbage. You had to have some kind of ability to actually tie it to that individual contractor. I thought that was reasonable. And then the other piece that we have here as well is that it comes with a start date of July 1 of 18. What that does is it sticks a clear flag in the ground. The biggest pattern that I heard in talking with contractors about this issue and in talking to council is that it was really hard to nail down when this actually went into effect. We have a Georgia DNR rule that took effect August 20 of 97. Prior to that, it was done county by county, and so what you had was a fairly confusing lay of the land for many of the contractors trying to figure out, am I breaking law, am I not? And the honest answer was it depended on where they were. And so rather than try to go and accidentally catch good actors while trying to catch bad actors, the real goal here is to make sure. I live in a district where just about every yard has garbage buried. My backyard has garbage buried. This wouldn't help me, but the goal would be to make sure that as Woodstock right now begins building again, that we can go into the future knowing this isn't happening anymore. We send a clear message from the General Assembly, this law is to be followed, and if you don't, you can be held accountable for it. So that's the bill that we brought out of committee yesterday.
Thank you. Let me ask you on this. I know there was a change of the date, and I've talked to Ms. Beskin, who suggested the date change. And
Yes, sir.
I think there was a concern that this would be something that would perhaps harm insurers.
Yes, sir.
Because they didn't know about this prior to this date, we'll say.
Right.
But in fact, we've had a law, really a rule and regulation by the Department of Environmental Protection Department since, as you say, back in August 1997, that says doing this is illegal.
Yes, sir.
So the point I'm getting to is, it being an illegal act, insurance won't cover it regardless. So the point being that if a builder does something that's illegal, and then a claim is made because of his illegal conduct through him, the insurance company says, I'm sorry, you performed, did work that was illegal, you're no longer insured on that basis, that part
Right.
of it. So I don't know if we need to do a July 1st, 2018 date, is my point.
Okay.
I'm satisfied saying we can do a date that goes back to when the law was enacted in August 20, 1997, and say prior to that date, you did something, it won't be counted against you. The point being, you do have what we call latent defects when you bury this material. Put dirt on top of it and grow grass, or put concrete. And I had a case
Right.
myself as a lawyer several years back where a house was built. They had the landfill. They put a driveway over it. One day a car fell in. Literally did, because the thing caved in with the weight of the car on top of that driveway. And
Heard more than one example of
yeah,
foundations.
so I mean, and I think most, let's say 99.95% of the builders do not do this now, but there's going to be some that still try to save a few bucks rather than take it to a landfill for disposal. And they may or may not get away with it. But I'm concerned about the date and maybe going back and using the prior date that we had.
Yes, sir. The original version of the bill that we brought did not have 97. What it did do, the piece that Representative Beskin was fixing was we had set it out to say that the actions that were still actionable as of July 1 of 18 would carry forward. And what that ended up doing was creating a very strange 8-year period of maybe you finished your house 7 years ago, but that action was still alive now, and so the date that we had changed. Now, the insurance argument, I think that's plainly a strong argument. For me, the July 118 date was more important because I felt like there was ambiguity amongst the community of contractors as to whether or not and when this became okay and wasn't. I think it's fairly clear if we go back and look at the DNR rule when that drop dead date was. I do recognize, and for lack of a better way to say this, my heart does go out to many of the contractors who I think were trying to act responsibly and genuinely didn't understand when that law had changed. And so my goal was simply to say, we're going to move forward with this. But again, this is certainly your committee.
All right, we got that understood. And,
I came with that well understood, sir.
we got any questions of Representative Caldwell, members of the committee? Thank you. We got Austin Hackney with the home builders. Come up, Ms. Hackney, and we'll let you address the committee.
Thank you, Mr. Chairman. My name is Austin Hackney. I'm here representing the Home Builders Association of Georgia, and we have around 3,300 member companies across the state who are licensed builders, and we wanted to say thank you to Representative Caldwell for involving us in his bill as I guess the party who would be most affected by this new liability outside of what is the established 8-year statute of repose on construction defects. And so our initial concern when we heard about this idea last year was that this is a new liability that we had not counted on in a business plan that goes into this kind of thing. So working with Representative Caldwell, he was very receptive to some of our concerns about the evidentiary standard that might go into what is such a complex arrangement with all the different contracts that you might have among the different parties in a construction. And so with that in mind, and with all the different owners of a piece of property that might be part of this transaction, we thought that higher evidentiary standard was a great idea. And so appreciate the subcommittee, their consideration of that issue, and the start date that was original to the bill did make it a little bit awkward as far as those projects that were kind of caught in the middle of that 8-year period. And so the line in the sand of July 1st really just made it as clear as possible to our members and anybody in the construction industry that this new discovery rule actionable accrual date is July 1st, 2018. There's no question. And so the confusion, I think, with the 1997 rule, at least from my perspective, is that the prohibition on construction waste burial came in the form of a guidance document from EPD that went along with their 97 rule. and gave an exception for projects on several acres. So the EPD rule, as I understand it, is not as clear as the bill that you have in front of you as far as what's legal and what's not, and when it's legal and when it's not. So I just wanted to put that to the committee to say that, you know, the guidance document from EPD leaves a little ambiguity there that our guys have had to deal with since '97, and I would say that maybe if this committee could hear from EPD and the guys who work in this particular regulation, that might be helpful to answer some of those questions.
Questions from members of the committee? Let me ask you, what you're saying is news to me. I thought the prohibition from back in '97, you're saying, was not a true prohibition as far as like building on residential lots
Well,
that have been subdivided.
It's not in there. In my research, I couldn't find it in the regulation, the rules and regulations of EPD, or in the Solid Waste Management Act. What we saw that prohibited construction waste burial was in that guidance document, and it was in prose of, you know, just that shouldn't happen anymore, except for on projects on several acres. And so it's
Well, let me carry it a step further. We have someone who had a house built and bought, but the house wasn't built back in, say, 2004. The builder did what we talked about, buried some trash in the area, then it got paved over or whatever. And now it becomes known, something happens, it's now 2018.
right.
And so you had your 8 years reposed plus the 2 years, you're SOL. Am I right? Is that what we see to be good policy, or just, what do we do? I mean, there's people that been caught, I know they've been caught longer than that, but what do you do if you're trying to enact something to be a policy protecting for those type incidents? Do you say you just really, I mean, gone to the 10 years, which is 8 years reposed plus the 2 years statute time,
Well, and I'm
latent defect?
And I think it's up to the committee to decide that, but I would say that applies to any tort in any case, in any statute of limitations. I mean, that's
Well, you have, of course, your statute of repose doesn't take into account what are the latent defects. It takes in what may be something material that cannot be known, like just the way it was engineered.
Sure.
It's there, but you don't know it was engineered improperly until something falls.
right.
That thing. Well, I just want to put that out for thought among the committee members with what they want to do about that point. Thank you, sir.
Thank you.
Any further questions, Mr. Hackney? Appreciate you
Thank you.
coming down. Is there anyone else who would like to address the committee on House Bill 704 that we haven't heard from yet? If not, then we'll close all further comment from the public. The bill is now on the breast of the committee. We're working with, as I said earlier, House Bill, get mine back up here, LC 363548, is it? I know. The what? We're talking about that. What we're talking about. Okay. We've had discussion among the committee members. Any comments? There being no comments, the chair will entertain motions. The motion is do pass. And do we have discussion on the motion? Any amendments? Are there any amendments to be offered? Well, I've talked about it. That's why I was asking Mr. Hackney about it. We could look at that as being the fact there would be a sort of a dark area, that if there were people who, during the time since that regulation was put in effect, still found a problem later there. And let's see. Let me read the wording here. This subsection shall apply to causes of action related to projects completed on or after. Okay, so we're saying the project has, something has to be done really as of July 1st, 2018. Then you'll have for the future this right to a tortious action against the person that did it. Okay, that's what Mr. Caldwell wants. Anybody want to offer amendments? We'll be glad to entertain them. If there being none, yes, sir, hold on. Mr. Holcomb?
Yes, Mr. Chairman. I'm not sure about the clearance of incident standards for 8 years later, because it's a lot harder as time goes by to gather the information. And just logically, if they allow the lower standard for the first 2 years, why do they need it higher for the 8 years? And maybe Representative Caldwell, I may have missed it during the discussion. I was reading through and I caught that as well.
You want to address that?
I'm more than happy to, sir. I've been lovingly referring to that as the King Solomon split the baby provision, and part of that is because where we found ourselves is we're effectively taking a current statute of repose and just outright eliminating it. So what we're not doing is saying, my preference here would be, rather than say let's extend the statute to 40 years or something like that, where we think we'll catch most of it. My worry with doing that is that we're starting to build with a lot more synthetic materials that theoretically could last and be sitting there in your ground for the next 200 years. The likelihood of your contractor still being around to hold accountable is low, but I don't want the state to be what gets in the way at that point. And so the goal was to open up indefinitely. By doing that, it does create, for lack of a better word that we've overused probably today, some ambiguity 200 years later as I'm trying to reference back and see, okay, who was this? I know there were 8 contractors on site building this house. One did the clearing, one did the house, well, if it's the materials that built the house, if it's the siding and the 2x4s then I probably know who to hold accountable. And I can probably meet that evidentiary standard. If I just found garbage and I found the name of one of the contractors, then I probably need to do a little more. So it does put an extra onus on the homeowner after that 8-year period, but I think that it's a rational, I think it's a reasonable onus, only in that it opens up that liability for so much longer. But again, I'm open to the will of the committee there. I would like to see that provision there. I feel less strongly about that provision than I do the date, the effective date. But I recognized when they brought that concern, that seemed rational to me, that because we're opening up so indefinitely, that there should be some sort of standard raised.
Understood. But with this being Mr. Chair, if I may follow up.
Yes, sir.
With this having an active date in the future, once it becomes law, then any actor from that point would be on notice in terms of how to behave. And so that's why I'm having a hard time just logically appreciating the different standards for proving whether 2 years or 8 years. In my mind, I think it should be the same.
I don't want to say I don't disagree with you, because I prefer this, I think, but I appreciate that. Well, I guess what I would say is if you were to move the effective date in reverse back to 97, then I would have to disagree. I think you'd have to maintain the higher standard. But if you maintain a future effective date, then I can work with and understand that rationale, because then I agree. I think you've set
The higher standards such as preponderance to clear and convincing.
Yes, sir. Does that make sense? I think if it's moving forward, then I think you've sent the message and that you could hold them to the message. If it's working in reverse, then I think having a higher standard is a fair expectation.
All right. Ready a time to think it over? We're ready to proceed. We had a motion for due pass. And I was asking for any amendments. Are there any amendments to be proposed? Yes, sir.
With the enactment date being in the future, which is I think what we're going with, then I would propose that we add a period at the end of line 37. After within 8 years of the date, some period right after the word date, and then the remainder of that sentence, which goes on to line 40, and then restart again with this subsection shall apply to cause of action related project after July 1st, 2018.
what I'm reading then would be just the understanding of motion is the sentence that begins on line 34, an action in tort to recover damages for such trespass upon or damage to real property shall be brought within 2 years after such cause of action accrues and shall be demonstrated by a preponderance of the evidence for any action brought within 8 years of the date, period. Striking the rest of that sentence.
Or,
Yes.
it might make sense to include that remaining clause of the date of substantial completion of such.
Why don't you read out what you're looking to have done? I'm not clear yet.
So, add the paragraph after improvement on line 38. My error on the first one.
Okay.
I think that's what makes sense to me.
Okay, you're saying the period would be after improvement?
Yes, sir.
So not after date?
Yes, and then it would strike to or by clear and
Okay, so I'll pause there, it makes sense now. An action in tort or to recover damages for such trespass upon or damage to real property shall be brought within 2 years after such cause of action accrues and shall be demonstrated by preponderance of the evidence for any action brought within 8 years of the date of substantial completion of such improvement, period. And strike out the rest of that sentence.
Yes, sir.
All right, and then what happens in the next sentence?
Keep that.
Keep that, though. Pick up again with, this subsection shall apply to causes of action related to projects completed on or after July 1, 2018, but shall not revive any cause of action which was barred by former law before July 1, 2018. So leave that sentence in. Does everyone understand the motion by Mr. Holcomb?
May I ask a question, Mr. Chairman?
Yes, sir.
So, Mr. Holcomb, I want to be clear. What is your goal here? To get rid of the clearing commitment standard for after 8 years. So we only have one standard. Since everybody will be on notice once, assuming this becomes law, once it becomes law. But the preponderance of evidence standard on line 37 for any action brought within 8 years of the date of substantial completion. So you're still going to have an 8-year statute of limitations, right? Am I missing something?
That's the period of repose, 8 years. Not statute of limitations is 2 years. Being a hidden defect, now the period of repose comes into play.
So I guess my question was, how are we changing the current law if we do it that way? Because I thought the next sentence is what gave you more time past the 8 years. And maybe I'm missing something, Mr. Chairman.
I don't know if it's out of turn for me to speak here, so I don't want to, Mr. Chairman, if you're open to it, I can tell you what it looked like before that clause was placed in, and then how legislative
Let me
council
answer this
drafted it.
question first. I don't think you need to touch by the 8 years in this statute. That is by a different statute.
Okay.
It comes into play by reason there being a hidden defect. The statute of repose would apply to it. A latent defect in the design or construction of real property improvements. That's what I understand.
So
Am I right, sir? Sounds right? Well, that's good.
So in other words, if in year 9 I find a hole, I can bring an action because of another statute that we're not looking at now.
That's right.
Is
You
that
have
if
a-
that statute already exists, why do we need this bill?
Well,
Mr.
that's a good
Jordan.
question. My thought was, that's why I said going back to look at the extend the opportunity of someone who's been damaged by this burial for the time going back to the date the rules and regulations were implemented, which was in August 1997.
That's something you had mentioned to me.
Yes, sir.
Yeah. And which I guess I'm looking for the chairman's direction on how he wants to go.
Well, you're back to where we talk about, you know, is this bill doing anything? It's already illegal to burial,
It is.
right, Mr. Caldwell?
Yes, sir.
So we already have 2 years plus 8 years.
Yes, sir.
What's this bill gonna give us?
The idea would be to extend it beyond 8 years so that when the garbage is discovered. it
Only
can be
after
held accountable.
2018.
Yes, sir.
So the people that have been harmed earlier that have no
You're correct.
right to
Yes, sir.
be able to go after who made that negligent decision to bury garbage.
As the bill's currently written, yes, sir.
Yes, sir.
He's trying to solve the problem going forward, not dealing with what's already occurred,
Yes, sir.
as I understood him.
Yes, sir.
Yes. And I'm saying.
And if you strike the portion that, if I understand it correctly, if you strike the portion Mr. Holcomb is talking about, you do away with what he's trying to accomplish, and that is provide a bigger period of time going forward.
Well, it would do that, but also this period of proposed would have the same standard, which it should probably have with the 2 years, which is just a preponderance of evidence.
I'm going to defer to the chairman on this one.
Well, I like Mr. Holcomb's proposed amendment, and I would have a further amendment. I'd say in this subsection shall apply to causes of action related to projects completed on or after August 22, 1997, period. That's the other change I make in it. That's my thought about it. Because we left these people in sort of a gray area back here that we're trying to protect going forward, but why are we doing it? And nothing gets accomplished.
I can tell.
Today. Yeah.
Correct. The intention of the author would be to ensure that as we provide this protection moving forward, that we're not catching contractors who inadvertently had broken the law and did have that statute as protection.
I don't call it inadvertent.
I understand.
Bury
Yes, sir.
trash, anybody with common sense, you bury trash and then you pave over it, you've done something wrong.
I
that's what it comes
believe
about.
that's where that rule came in '97 was for
Yeah.
exactly that purpose.
Yeah.
My house was built in '92, so either way it doesn't help me. I yield to the will of the committee. The goal was to try to plant a flag, but
Mr. Holcomb.
Mr. Chair, I think I was wrong in my first proposed amendment, and probably the thing that makes it clearer, because it has different standards for both before and after 8 years, would be to put the paragraph on line, or the period, on line 37 after evidence.
Okay.
So then there's not two different standards for before 8 years and after 8 years.
Point well taken. So we don't need to, we don't need to refer to the 8 years.
Yes, sir.
The 8 years goes with another statute. Shouldn't go in here. That frankly confuses the statute when we try to include it in here.
Yes, sir. That's why I think if we add the period after evidence on 37, it makes it clearer as to what.
You want to amend your motion?
Yes, sir. I'd like to make a motion that we amend this by striking, or rather adding a period after the word evidence on line 37, and then striking the remainder of that sentence through the word improvement on line 40, and then retaining the following sentence.
So an action in tort to recover damages for such trespass upon the damage to real property shall be brought within 2 years after such cause of action accrues and shall be demonstrated by a preponderance of the evidence, period.
Yes, sir.
Okay. I'll second that. All right, motion's been made and seconded. Any further discussion? Yes, sir, Mr. Strickland.
So just help me understand with this amendment, how is this bill before July 1st of 18, this, the past 12 months, this will not.
That hasn't been addressed by this amendment.
Okay.
That hasn't been, the only thing we're addressing at this point in time is the preponderance of the evidence rule in the 2 years, which really is already law anyway, but,
Right.
but we're just putting that down
Okay.
in this bill. All right, so you have The Holcomb Amendment, everybody understand the Holcomb Amendment? We'll call the question on the Holcomb Amendment. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Do we have any further amendments? There being no further amendments, the chair will call the main question, which is a do pass as amended and committee substitute of House Bill 704, which is LC 363548S.
Can I get some clarity?
You want clarity? What's your clarity?
So, so it's not going to be August 20th, 1997. It's going to
No,
be.
sir.
Okay.
That's not an amendment.
Okay.
That's not an amendment. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. We have a due pass. House Bill 704.
Mr. Chairman, thank you very much. Members of the committee, thank you.
Paid extra for coming.
Okay. Meeting is adjourned. Got all the bills done.